In this review of the third set of cases, I'm going to do things a little bit differently than the first two reviews. I'm going to try to focus kind of what you did and how these cases relate to your final exam, so that you're kind of turning the corner and thinking about that now. Remember that my hope was that as you went through each set of cases, starting with race and participatory politics, then moving to balancing interests within criminal justice, and now here you're looking at intersectional injustice of race, sexuality, gender, and class, that you'd start to understand how the state and the legal system can limit rights or take rights away as a form of social control, and how social justice groups mobilize to try to get those rights seen, recognized, implemented, or expanded. So just want to remind you again that the grading was based on the rubric, right? And so how clearly you are answering the questions within these concepts that you're supposed to be learning through the course reader. And just to remind you that each of these is worth 10 points, right? So not a huge impact on your grade, but enough to give you a signal as to whether you're improving. So hopefully your grade improved over the three sets, even if it was, even if you were struggling. Again, this is one part of the exam where you're going to do an analysis and a long response, and so I want you to be able to do it, but it's not a huge impact on your grade. What I decided to do here was to show you how this applies. So one student did a near perfect job in identifying the rights claims, and so those are here in green because they match the framework here. That they're putting these within a contextual framework using legal language, understanding how judges are interpreting, and really applying it here in this third set of cases. And what I want to do is contrast to these in pink, right? So these are the answers that aren't doing that. Now, what they're doing is it's just showing me that it's not clear whether you're reading and applying a critical analysis of the cases because of these answers. The question here was, what's the rights claim? So you can see, very just fundamentally, the student is writing the rights claim was, right? Or they were including the rights claim in their language. That's always a good idea. These two answers over here to the left in pink don't say anything about a rights claim. So my suspicion is if you don't say anything about a rights claim, you're probably going to get it wrong, right? Because you seem to be answering a different question and not the one that I asked. The other issue is that the student here on the right is really, articulating the relationship between the claim, what the person is saying that they're entitled to, what their right is, and the injustice and the issue. And so there's a relationship there that shows me that they're able to see that this is how judges interpret cases. So again, for prepping for the final exam, this is how I want you to start to see things, that you're able to identify the injustice, the thing that the person who's bringing the case to the Supreme Court is saying, this was wrong, that this thing happened to me, and now I've got a rights claim that I'd like to bring to the court for you to resolve. Many of you are still focusing on the politics, on what's going on at the state level, and whether you agree with the politics or not. That's fine for a political science class, right? But it's not good for a constitutional law class. Here you're supposed to be putting your mindset into how does the judicial opinion respond to your positionality, to your standpoint, but not to your opinion about greater politics. It's what's the relationship between your position as a citizen and how that relates to your own rights claims. And so this is where you want to be thinking as you move forward. How does the rights claim and how does the injustice respond to your ability to also enforce a rights claim? So if the court takes something away from one person, it's also taking that away from you. If it expands rights, then it also expands rights for you. It doesn't matter whether you are, let's take the example of same-sex marriage. It doesn't matter whether you're heterosexual or homosexual or transgender, transsexual. That's irrelevant, right? What matters is that if the expansion of the rights is granted, then all three groups of people get expanded rights. If those rights are limited, then one group is getting expanded rights while the other two are being excluded. And so that's how you need to start thinking about your own standpoint, right? Are the rights expanding for you? Or are they being limited? Are they being constrained? Not whether you agree with the politics of the issue. So when we're thinking about injustice, you want us to also connect this back to the readings to show me that you're applying the concepts from the course to your answers, and that this shows me, A, you're not getting the answers from Google, and B, that you're starting to really think through and be able to critically analyze the issues. I pulled out some things that you might want to think about for the final exam. You want to think about the contrast between Dworkin's belief as morality in the law, but also the kind of Sotomayor and Patricia Hill Collins argument that law is experienced differently by different people. And so the sum total of that is that the legal system and interpretation will depend on your experience and your belief system. So there'll be multiple interpretations. That's not a bad thing, right? That's part of democratic politics. Some of you are still seeing that as bad. Basically, if there was only one moral interpretation of the law, that's called a dictatorship, right? That's some countries have that. There are no choices. So the situation in Iran, right? One group gets to decide whether women should wear the hijab, the head covering. So that's not, I think, what you are referring to when you think about one idea of morality. And so for there to be multiple definitions of morality or what's right and wrong, that's evidence of politics. That's evidence of democracy. And so the court should reflect that. There should be multiple interpretations within reason, right, in the court system, because they'd be reflecting that reality in the political system. And so that's what I want to start you to see, that there's people experience the legal system and injustice differently, and so their rights claims are going to be similar, but their experience of injustice is going to be different. That's what you really need to start focusing on for the final exam. So moving forward then, we want to look at the idea of formulating your answer so that you're getting towards an A, right? So I like this, the way the student put their representative answer of what they thought their standpoint, right, is that they're showing me that they don't agree with the outcome, which means they understood the outcome, and they're able to analyze that what Planned Parenthood did was actually restrict. It's more domination. It doesn't have an expansion of rights. It limited women's rights to reproductive services. And so that's showing me that they're able to start to think about this within their own frame of mind. That also shows me that they understand unequal social relations and how judges are operating within that. I think this also brings up ideas that I'd like you to see in this case, that men largely are making these restrictions on women that they don't apply to themselves, right? So they don't reduce their right to cheat on their wives, or to have multiple sexual relations, or to engage in sodomy, or engage in illegal activity with prostitutes, right? They're not limiting their ability to go see the doctor for conditions caused by sexual transmitted diseases, right? So this is an unjust law because they're passing a code, a moral code, that only applies to women. It doesn't apply to them. They're not willing to follow this system of law. So Martin Luther King Jr. and others, philosophers, have called this an unjust law, an unjust use of the legal system. You also hear, I think, see Patricia Hill Collins' argument that women have to reclaim their power, political power, and their voice in order to get their injustices heard. And so when that doesn't happen, so a lot of women kind of stopped protesting and stopped organizing after Roe v. Wade, then you start to see states start to take the right away. And so you can't see the court as giving rights away. You have to see people earning their rights. They're going in and saying, we demand these rights, and then the court sometimes responds. And so if people stop doing that, then their rights will slowly be taken away again. And we see this fully in the Carhart versus Gonzalez case, which basically completely took the rights away from women. And again, this is an idea of a contrast, like what you saw in the first section, between how American Indians were treated, right? The law was not really applying to them unless it was criminal, right? Unless they were trying to control American Indians. But then their land rights were taken away. So ideally, everybody gets equal rights, but in practice that doesn't happen. It's the same thing going on here. Ideally, women would get equal rights with men, but clearly that's not happening here. And so again, a lot of you tended to focus on the state politics of it and not the legal side of it. And that's frustrating, as over time you'll start to hopefully change that if you continue going down the criminal justice major or the law major. But for now, you just need to start to be able to see that the unequal patterns of social relationships, so if men have more power over women in the political system, that's going to determine how judges also see the structure. And so there's a tension there between, in this case, men trying to control women and women trying to exercise their rights. And so you have to start to think about how both groups are using the legal system to enforce their view of what they think the law should be. So then this brings us to go back in time to start to better understand the right to privacy, which comes out in Griswold versus Connecticut. But you have to start to see then that the right to privacy is going to be different based on your own legality narrative. If you tend to see the right to privacy as before the law, as the law is a mysterious automatic rulemaking machine or a set of standard rules or a reflection of morality, then you would more likely say something like, if the majority of people say that it's immoral to do some act, then they're saying that that's more important than your right to privacy, and you're going to go with it because you're before the law. Some of you might say, well, if I think I have a fundamental right to my body or to my family decisions or the right to marry someone I love, then you're going to feel like the law is up against you. It's coming up against you and you have to defend yourself against it. You have to resist it and really try to exercise your rights and say, hey, no, this isn't fair. If you're with the law, then you're arguing that the law is a game, and whoever kind of plays the game the best, whether it's the Democrats or the Republicans, or whether it's men or women, or whether it's same-sex people or heterosexuals, right? Whoever plays the game the best in the court system, whoever's got the best case, they're going to win. And so those three different views of the legal system are going to also mean that you have three different views of what privacy means to you and what you think should be counted as privacy. And so this is really important for you to start to understand that all of these three things happen at the same time, that they're always going on, and that there's always kind of competition between and among them. So then this shows us really clearly what's happening here is one legal view of what obscenity is, which of course, if you go onto Twitter, social media of all, if you go into the dark web, if you even watch shows like the Kardashian shows or South Park, those people could all be prosecuted for obscenity if the courts decided it was time, and if police decided it was time to go ahead and start exercising their right to social control. It's a kind of a mystery why that isn't enforced in the same way that it was enforced in Miller versus California. So here you see much more domination, right? Your First Amendment is severely limited by other people's morals, by what one group of people calls moral and what the other does. The effect of those morals shouldn't matter, right? Because otherwise, if somebody says, well, I don't want my children to be exposed to X, Y, and Z, well, take care of your children, I think is the bottom line, right? If you're saying you have a fundamental right to decide what your family does and doesn't see, well, then you are responsible for that, not the larger social structure. And then, somebody could say the same thing, well, I don't want my children to be exposed to liberal ideas. Or liberals could say, I don't want my children exposed to conservative ideas. I don't want them to have to hear about Christianity, right? Obviously, when we start limiting the First Amendment that way, it's only going to be the group that's in charge, the one with the dominant power relations, that's going to limit everyone else's right. And so that would be a restraint on your rights, not an expansion. So just because you don't agree with one political issue, doesn't mean that other political issues won't limit things that you do care about, right? And so if you start limiting First Amendment rights, then there's going to be a lot of things that you can't do. And so that's what you need to be thinking about in this kind of situation. And then this also comes back in Texas versus Lawrence, but what's interesting about Texas versus Lawrence is that now the court at this point uses the right to privacy to kind of cement or to make it clear that states can't pass laws that criminalize certain behaviors between consenting adults. And this is really, going from the 1960s all the way up to 2000 of saying, states have to stop doing this, right? States keep doing it. They keep passing laws democratically. Their majority populations are saying, we want these laws to interfere with individuals' lives because we don't like what they're doing. The court says, no, you can't do that because of the 14th Amendment. So you have to start to see that this then goes back to that philosophical belief, right? If you believe that privacy interests are the most important thing, that they're the fundamental thing, then you're going to agree with this political case. If you think that social control and that people should be more moral, right, and that your definition of morality is the only one, then you're going to disagree with this case. And so you see what the court is doing is trying to balance. And both groups, those are saying that homosexuality is immoral, and those saying that it's a First Amendment, or it's a fundamental right, are both using the law to try to change society. And so you have to start to think about, if social movements, I don't want to say get lazy, but if they stop pushing for their rights, then we'll just keep seeing the other group will try to take their rights away. So you have to see this constant struggle between social control and resistance. The court doesn't settle that debate, right? If anything, it just tries to explain how constitutional law applies, but people can obviously disagree, and other courts can change the opinions later. So we also see this as a pretty simple case, right? Loving Virginia, you think in today's society, well, of course everyone has the right to marry someone, even if they're from a different ethnicity, nationality, a different skin color, right? Of course, that's obvious, right? Well, no, it's not obvious, because for 200 years this wasn't true, and it's not listed in the Constitution as one of the rights, right? There's not a 30th Amendment says you have the right to marry anyone you want. That's not a right. That's a right that the courts have interpreted based on people organizing and social movements saying we have these civil rights, civil and political rights. And so, as Dr. King explains here, right, nothing is ever well timed here, right? When you have these people who are pushing to separate people, or saying that we want to control you, or we think this is a crime, which was in the case here, then you have to have other groups pushing back saying, no, we have a fundamental right to this. Nothing is automatic, right? So this is all taking place within the politics that the court is trying to figure out how the law applies. And so you have to see this tension again between social control and law's rights, and see that this is because in the politics of democracy, where people get to exercise their opinions, you're going to see this unequal power struggle. And so this is a constant thing. So this is what brings me to the dilemma, right? Is that many of you are kind of buying into this myth of the courts granting rights over time, or what we call the myth of progress, right? And you're not seeing them as struggles that happen each generation. So it's fine to say that in some ways things have progressed, right? But then all of a sudden you have a case, Dobbs versus Jackson, that came out this last year, right before we started our class, in which the court very clearly says that they could go forward in the Thomas opinion, saying that they could undo all of those cases that you just said were progress, right? So they could change all of that and go back in time, just like they did with the reproductive rights. So those cases you saw from Roe and from Roe, right, there was the right to the fundamental right of privacy, and that included the right to get an abortion. But that got bounced back then with Planned versus Parenthood. They started to limit that right. Then they limited it further in the Carhart case, and now this year they've taken the right away altogether and given it to the states. Now states get to decide whether women have the right to an abortion and other reproductive services. So many states have said no, women don't have that right. So what you saw was progress over 50 years has now been wiped out with one decision. And that can happen the same thing with the right to interracial marriage, same-sex marriage, the right to privacy in general, right? So any privacy rights that you think you have can all be taken away by the Supreme Court. So this is what we were talking about at the beginning of the class about the civic and education gap, right? It's all the things you don't know, all the legal cases. We can't cover every single legal case in one class, and so we highlighted on some of the major ones so that you could see how the court makes its decisions, but how unequal social relationships are really what show you that this conflict is necessary, right? That people are out there arguing in the political structure and organizing and trying to use the law as a tool to defend their perspectives. And so if certain people, let's say white male Christians, have more power in society, you're going to see that be reflected in the court cases over time. And so you have to start understanding this from an intersectional, which is 3, right? Imagine you show up to an intersection in your car, right? There's, you're there in one lane, right? But you look to your right, there's a street, then you look to the left, there's a street, and then there's a street on the other side, right? So there's 3 points of view, and that's race, gender, and class. And so when there's unequal power relationships, when one race or one skin color or one nationality has more power than the others, then they're going to use the law as a tool to defend themselves and dominate and control other groups. If men have more power and control in society than women, then they're going to use the law as a tool to, again, protect their rights, but they're going to limit other people's rights. Same thing with social class. If it's mostly wealthy people or privileged people or well-to-do people, then they're going to limit the rights and control those who don't. And so it's not going to be equal because society isn't equal. And so the law isn't an automatic equality machine, right? It's going to be within that same issues of inequality that you see in society. And so you want to start to be able to understand this over time, that this is constantly, right? Constantly, as Arendt said, people have to be recognized as being worthy of having rights, or the right to have rights. But when in the social political structure, that is exactly what people are not recognized to have rights. And there's 100 issues we could talk about if we had years and years and years. Which, if you go into keep staying with criminal justice, law and society, or law, you'll be able to do that. Just keep learning more and more and more about these unequal social structures and whether law can be a useful way of trying to equalize them. Right? Sometimes it works, most times it doesn't. So this brings us to, again, really narrowing in on the rubrics, right, and showing me how you understand the concepts in the course, and that you're not just having knee-jerk reaction opinions, but you're starting to critically analyze. And so, you have to start thinking, two-word answers aren't going to be a good idea on the final exam. You got to be able to explain how variations in interpretations, right, whether those are conservative, whether they're liberal, whether they're a living constitution, whether originalism, are actually having an effect on the outcomes, right, on how society interprets those rulings and how they employ them. You also have to describe how judges interpret the constitutional text. So when you're reading the cases, you're trying to look for clues as to how that judge is interpreting the case. Is it that they believe in privacy? Is it that they believe in rights? Are they trying to expand rights? Are they trying to give states the power to control people? Are they trying to resolve a political issue? Right? You have to be able to explain this to me. And you have to start to show me that it's not just about procedural rules. It's not automatic, but in fact that there's very malleability is the better word than loophole, right? But that people are arguing in front of the judges and they can't do whatever they want. They're constrained by certain legal procedures, but those procedures don't dominate, right? They don't determine what the outcome is going to be. And then you want to start to put this in prospect of how this, is applying to you. A lot of you are still struggling with this, right? So you have to start to see yourself as, are you being socially controlled, right? Regardless of whether you disagree or agree with the politics, or are rights being expanded? Because that's the framework that we operated in. And so you're going to start to be able to show me that you better understand how judicial decisions affect social relations. Do they maintain domination? Are they increasing domination, like in the Miller versus California case? Or are they starting to decrease domination a little bit, right? In Texas versus Lawrence, it's giving less domination. It's saying you can't interfere with people's sexuality, right? You can't break into their houses and determine whether they're committing a crime of sex, right? That's too far. So that's how you want to start to, there's this tension. People want to do that. The political structure wants to break into your home and tell you what you're doing is wrong morally. And there's lots of people who agree that they should be able to do that. There's entire social movements that are arguing that the police should be able to do exactly that. But then you've got people who are arguing, saying, no, we have rights to be free in our bedrooms, we have rights to marry who we want, we have rights to do what we want with our body. And so these are creating a tension that's back and forth, a seesaw, however you want to think about it, right? That these groups are going up against each other, trying to use the law to say, well, this is what we want it to be. And so you want to start to think about how rights claims, how they talk about their rights, how they use their rights, is leading to their awareness of saying, hey, we need to stand up to injustice in the way that Dr. King was talking about. And then finally, I just want to throw out some basic ideas here that you're going to start to think about, that you're going to, for the final exam. You really want to start thinking about the philosophical differences that start from different experiences. So women are going to have a different philosophy than men. So you're going to see a different way of thinking about legal cases from Justice Sotomayor. You also want to start to contrast the belief that there's it would be lovely. I'm right there with you. Wouldn't it be great if everyone were angels, everybody did what they were supposed to do, the law was automatic? You wouldn't need law though, right? If everyone was perfect, law would be unnecessary. And so because law is constructed by us humans in a political structure, there's going to be different definitions of what people mean by law and what they think morals should and shouldn't be. And you're not going to agree with everybody on what morality is. And so this is how we get this kind of interpretive process, right? People are constructing law and interpreting it in the process. And so you want to start to see, how do these groups use law as a tool for social change? If you can do that, you're going to be able to see that sometimes the legal system and the legal rules work against social change, and that's why people are up against the law and they're trying to make social change. But other times the law works in their favor, right? So the fundamental right to privacy, for example, is helping people who are trying to change society. That will help you be better able to analyze judicial decisions within this structure of domination, less domination, or towards equality. There aren't, with the exception of, let's say, the 14th Amendment was really close to equality, not quite, right? But it put in the language equal protection. And so if it would have been a little bit further, there's more they could have done to make material reality here on earth, right, where everyone was actually equal, then you'd see equality, right? But it didn't quite go that far. And so this is because social relations are unequal. So as long as there's domination in social relations, as long as some groups are being treated and have it better than others, then the legal system is never going to be able to give you equality, right? It's going to be used to argue for less domination or more domination, depending on, right, how you feel about that. This also means that law is not a universal ideal, regardless of what Google search says. It'd be lovely, wouldn't it be nice? But it's not like, the rules of gravity or the thermodynamics law, right? They're not scientific laws. They're rules that people are coming up with in a political atmosphere. They're imperfect, they're unequal, and they have to be interpreted. This will also help you better see that it's not progress, right? Sure, some things have progressed, but they progress within generations, not over the last 200 years. Right, so there's lots and lots of arguments you can look for, but you'd look for modern slavery, right? You probably don't know about it. These are all the things that you'd have to learn about to find out how slavery functions. More recently, you saw a couple states finally ban slavery in their prison system, right? Now, that means that they had slavery in their prison system, which means they still do, but they're saying they think that needs to change. They want that to be over, and that's because social groups argued that they, needed to change. Right? And so this is the tension between social control. There's some groups that say, no, prisoners should be slaves as a part of their punishment. Other people say, no, that's cruel and unusual punishment, right? So you see this kind of tension, this two groups competing with each other over what they think the laws should be and how they should apply and how they should be interpreted. This now will give you a contextual framework in order for you to think about lived experience. Think about your own lived experience, but probably more importantly, think about other people's lived experience who are different than you. Right? That's the goal of this, is that your perspective is not the only perspective in the legal structure, and so you need to start to see that. But you also need to be able to see that if there's 6 white men or 6 white people who believe in conservative Catholic values, that's how they're going to interpret the legal system, right? If you have somebody who's an Asian atheist, their lived experience is going to interpret how they think about the legal system, what they think the law should be. If you're a recent immigrant, right, you're still thinking about your home country and the rules and social patterns there. That's going to influence how you think about it. Depending on what your social status is, right? Are you a millionaire? Are you a professor? Are you a student, right? We have different rights. We have different ways of thinking about the legal system. And this will apply to all controversies, from racism to criminal justice issues, violations of the 4th, 6th, 8th, and 14th Amendments, intersectional issues of race, class, and gender and sexuality, and also modern challenges of state administration, right? Whether the United States can limit greenhouse gases and save the environment, whether they're able to tax people for consumption on their own property, whether they can, criminalize marijuana, right? All of these issues about social control and rights are always going to keep coming up as cases and controversies. So this is never going to be resolved so long as we have the legal structure we have. So again, I'm not expecting you to understand every single detail. I'm hoping you just start to move towards this on the final exam, because you're going to be asked to do this on a long response, right? Kind of like an essay response. And so you want to start practicing on that. It's only one small part of the exam, but it shows me, have you got it? Are you at the A level, or are you struggling somewhere between the D and the B level, right? Are you working it out, trying to make sense of it all? And that gives me a better sense of what grade you should get for this class. All right.